Hello, my name is Jenna Nand. I am an attorney with Fortuna Law, PLLC, a law firm located in Linwood. I'm here to present to you information on the coronavirus and its impact on small business. As you can see, there is a wide constellation of entities from the government, federal, state, and local level, which have mobilized in response to the coronavirus and its disastrous impact on small business. In this presentation, I will attempt to lay out general information about each program from each level of government. And if you are interested in receiving more detailed information that would be pertinent to your business, feel free to reach out to me at the contact information, which will be on the last slide. Nothing in this video should be construed as legal advice pertinent to your specific situation. So the authorities governing the coronavirus from the federal level are Congress, various federal agencies. The ones pertinent to small business are the Department of Labor and the Small Business Administration. Here in Washington State, we see authority and guidance and restrictions coming from the governor's office, the Washington Employment Security Department, ESD, and the Washington Department of Commerce. On the local level, authority is coming from the Snohomish County. For example, Executive Dave Summers' new program called the Office of Economic Recovery and Resiliency, and at the municipal level from the mayor's office here in Edmonds. Starting with the federal level, Congress on March 19th passed legislation called the Families First Coronavirus Response Act, which became effective on April 1st of this year and will be in effect until December 31st. It applies to all covered employees, including businesses with less than 50 employees. It provides 2 weeks, which is up to 80 hours of paid leave at the employee's regular rate of pay, where the employee is unable to work because the employee is quarantined and or experiencing coronavirus symptoms and seeking a medical diagnosis, up to 2 weeks or 80 hours of paid sick leave at 2/3 of the employee's regular rate of pay because the employee is unable to work because of a bona fide need to care for an individual subject to quarantine or care for a child under the age of 18 whose school or child care provider is closed or unable to provide care for reasons related to COVID-19. It's important to note that if you are an employer who is affected by the statute, that it is up to 2 weeks or up to 40 hours per week. So if you have employees who are part-time and who are working less than that, they would receive paid sick leave or paid family leave commensurate at the rate at which they normally work. So if they only work 15 hours a week for you, then they would receive that amount of paid leave. This went into effect on April 2nd, and it provides for employees who have been employed for at least 30 days, with up to an additional 10 weeks of paid expanded family and medical leave at 2/3 of the employee's regular rate of pay. The employer is not required to pay for the first 10 days of such leave. In Washington State, where paid sick leave became law in 2019, employees should have already been accruing paid sick leave at a rate of 1 hour per 40 hours worked, and the employee must exhaust all of their accrued paid sick leave before the FFCRA sick leave requirements kick in. Meaning that if you had an employee who had worked 5 weeks, for example, 40 hours a week, they would have accrued 5 hours of paid sick leave, and they would have had to use that before they can begin drawing on the sick leave provided by this act. So the impact on small businesses is that businesses may claim any paid sick leave or family leave that they have to pay out due to this legislation on their tax returns. There is no civil liability for businesses with less than 50 employees who violate the act. And caps on benefits for businesses with less than 500 employees are, they employer can be forced to pay $511 per day or $5,110 in aggregate for paid sick leave used by an employee who experiences symptoms of COVID-19 or is required or advised to self-quarantine, or $200 per day or up to $2,000 in aggregate for paid sick time used by an employee to care for the employee's child or other impacted person. There's also an exemption to maintain what is being called the viability of small business. And there's a reason why I put that in air quotes. According to the Department of Labor, businesses with fewer than 50 employees can seek an exemption from providing childcare related paid sick leave and the expansion of family and medical leave if doing so would affect what the Department of Labor is calling the viability of the small business. However, there's questions about what qualifies as viability. It's not been defined yet. So to elect the small business exemption, business owners should document why their business with fewer than 50 employees meets the criteria set forth by the department, which will be addressed in more detail in forthcoming regulations. So we should see a definition of what viability means and how the degree of hardship that a business has to experience for its compliance with the FFCRA to be considered a threat to its continued viability or existence soon, but nothing has been issued yet. The Department of Labor's website also notes that please do not send any material to the Department of Labor when seeking a small business exemption for paid sick leave and expanded sick leave and medical leave. You should just continue to accrue and document the information yourself and wait for the forthcoming regulations. Second legislation passed by the federal government is the Coronavirus Aid, Relief, and Economic Securities Act, called the CARES Act. It was passed on March 27th of 2020. It's a $2 trillion aid package for business. Small business assistance, for example, creates a paid leave provision. So it creates, as we previously discussed with the FFCRA, the limitation of $511 per day or $5,110 in aggregate for sick leave, or the $200 per day or the $2,000 in aggregate for quarantined individual or child care of each employee. So it expands eligibility for the entities suffering economic harm due to COVID-19 to access the SBA's economic injury disaster loans, and the size of the loan would equal 250% of an employer's average monthly payroll. The maximum loan amount would be $10 million. So additional information on the CARES Act are that it provides that net operating losses arising in a tax year beginning in 2018, 2019, or 2020 can be carried back 5 years and temporarily removes the taxable income limitation to allow an NOL to fully offset any income. Landlords are prohibited for 128 days from taking any legal action to recover possession of a rental property for non-payment of rent or other fees or charges. The provision applies to any property where the landlord's mortgage is insured, guaranteed, supplemented, or protected by federal agencies or programs, Title IV. So the SBA, the Small Business Administration, first began routing its COVID-19 relief aid through economic injury disaster advance loans, which would offer up to $2 million in assistance per business. So the loans could be used to pay fixed debts, payroll, accounts receivable, and other bills that can't be paid because of the disaster's impact. The interest rate is 3.75 for small business. The interest rate for nonprofits is 2.75. To apply for an SBA disaster loan, small businesses must provide a personal financial statement and a schedule of liabilities. A second program, which has become very popular very fast, is the SBA's Paycheck Protection Program, called the PPP. So this applies to small businesses and nonprofits with less than 500 employees. It will provide a loan up to 2.5 times monthly payroll, again, the 250% that we saw in the CARES Act, the entirety of which can be forgiven if it is used to keep employees on payroll. By definition, employees can include the business owners and any employees for their first $100,000 of annual compensation. So when you're calculating payroll, the business owner can pay him or herself and any of their employees up to $8,333.33 of their monthly wages or salary. That's the only portion that they can claim from the federal government through the Paycheck Protection Program and then expect to be forgiven. The best way to do this is through an SBA lender, as many lenders are presently overwhelmed with applications at this time, and some are attempting to put restrictions on whose loan applications they'll process based on the relationship with the bank, which was not foreseen or permitted in the SBA final statement. So yeah, good idea just to stick with previously approved SBA lenders. So in Washington State, the governor's office on March 23rd issued its stay-at-home, stay-healthy order. So non-essential businesses were ordered to close or provide remote pickup services. Essential businesses include the emergency services sector, food and agriculture, energy, water and wastewater, communications and technology, financial services, healthcare, especially for vulnerable populations. A full list can be found at the link included in the slide. The order will be enforced, and businesses in violation can be reported and actually are being reported through a portal that the governor's office has put on a website. There's a 30-day moratorium on evictions that started on March 18th, 2020. And complaints are being received by the Attorney General's office about landlords attempting to apply fees that aren't considered rent, and then when their tenants are unable to pay the fees, attempting to evict them for that. The Attorney General's office is taking those complaints very seriously, so I strongly suggest that none of any landlords out there attempt to apply a workaround like this. The Washington Employment Security Department, DSD, has recommendations for businesses that have been forced to close or reduce their operations. The first is that you put employees on shared work. So this program allows employers to reduce the hours of permanent and hourly paid employees as much as 50%. And then those employees can collect partial unemployment benefits to replace a portion of their lost wages. While on the shared work program, employees are not required to make an active search for other employment, which is a normal requirement for unemployment benefits. Partial employment, so for reductions in hours, businesses may temporarily reduce hours of work for their full-time employees, and the employees may be able to receive unemployment benefits without having to look for a new job as well. And then standby. A business's employees may be eligible for standby, which means that they do not have to look for other work, but need to be available for any work that you, the employer, offers that they can do if quarantined or isolated. ESD may grant an extension of standby for more than 8 weeks if the business makes its request in writing can show extraordinary circumstances. Washington State also recently announced its Working Washington Small Business Emergency Grants. Washington Department of Commerce is offering emergency funds of up to $10,000 for small businesses. To qualify, a business must have existed for at least 1 year, must have between 1 and 10 employees, including the owner, must be able to, that's supposed to say, demonstrate that they have been impacted by the coronavirus disaster. Nonprofits are ineligible for this program. The funds may be used for operational expenses such as rent, supplies, inventory, utility bills, as well as consulting, marketing, and training. Various counties, including, unfortunately, 2 of the largest counties in Western Washington, King and Snohomish, are not presently accepting applications. However, various counties in Eastern Washington and Pierce County, which is where Tacoma is, are still accepting applications. So if you are in one of the counties that is currently putting a pause on their program, keep an eye out for when they will be opening up their application portals again. And if you're in one of the other counties, I recommend that you get your application in as soon as possible. Right now, Snohomish County has created the Office of Economic Recovery and Resiliency. So Executive Dave Summers is going to create this office. The primary focus will be to stabilize the local economy, plan for economic recovery, build resiliency for our local employers, and support our local workforce. The office will assist local businesses in recovery and workforce training and help organizations get our residents back to work, while partnering with human service providers to support those most in need. The City of Edmonds the mayor's office released its stay-at-home order on March 22nd, 2020. Since then, like many municipal level governments, the city has stayed mostly silent so as to avoid creating confusion with state and federal level guidance and restrictions coming out about the coronavirus. However, our private sector here in Edmonds has been very busy. The Edmonds Chamber of Commerce is providing grants through its Wish Fund when inconvenient stuff happens. 2 websites have come up, loveedmonds.com and keepedmondsstrong.com, which are providing a directory of local Edmonds businesses and also attempting to support the community in various ways. So even if you find that there's not a good fit for you when it comes to some sort of aid or security or relief program from the government, definitely look at the nonprofit and private sectors and see what's available to you as a small business owner, because there's a lot of support from those 2 sectors as well. I also want to remind people, business owners, about medical privacy and what to disclose. Under the Americans with Disability Act, you cannot divulge information about an employee's health status, including whether they have been infected with the coronavirus. So under direction from local authorities, such as here in Edmonds, the Snohomish County Health District, you may disclose that an employee, without mentioning the employee's name, has been diagnosed and thereby warn his or her coworkers, your customers, and the general public. Lastly, if you have any questions or if you'd like to learn more information about any of the programs presented in this video or schedule a free consultation about your business's legal needs, you can reach me at my law firm, Fortuna Law, PLLC. My phone number is 206-504-2626, extension 1, and my email is jnand@fortuna-law.com. Thank you.